Good afternoon. My name is Clayton Bankson, and I'm a member of the faculty here at the University of Saskatchewan College of Law. Welcome to the Estey lecture in business law, titled Commercial Law at the Crossroads. To begin, I would like to say a few words about the Estey Chair in Business Law, which was established in 2012 by John and Bill Estey in honor of their late father, the former Supreme Court of Canada Justice Willard Bud Estey. To date, their $2 million donation is the largest private donation ever received by the College of Law. The Estey Chair is intended to attract outstanding scholars in the area of business law. Chairholders teach business law courses within the college, conduct research in their field, and share their expertise and engage in outreach activities with the wider legal community. It is my honor to introduce the holder of the college's inaugural Estey Chair in Business Law, Professor Roderick J. Wood. Professor Wood is the F.R. Matthews Professor of Business Law at the University of Alberta. He teaches and publishes in the areas of secured transactions, bankruptcy and insolvency, debtor-creditor law, and commercial law generally. He is the author of an influential treatise on Canadian bankruptcy and insolvency law, co-author of Canada's seminal personal property security law treatise, and co-author of several other books on secured transactions in Canada and New Zealand. He has penned over 24 articles in various law journals and is widely regarded as one of Canada's top minds in the commercial law arena. Professor Wood holds law degrees from this college and the University of Toronto. He has served as Associate Dean of the University of Alberta Faculty of Law, a board member for the Alberta Law Reform Institute, and a Commissioner of the Law Commission of Canada. He was a member of the Canadian delegation at diplomatic conferences in Luxembourg and Berlin, which produced international instruments governing the secured financing of rail assets and space assets. Professor Wood has been the recipient of numerous teaching awards over the course of his career. I can attest to his teaching prowess. I think I hold the record for a number of classes taken from Professor Wood, that number being 5. And on a personal note, Professor Wood has been a source of inspiration, guidance, and support as I've embarked on my academic path. So for this, I'm very deeply thankful. So both I and we at the college are very fortunate to have Professor Wood here, even if only temporarily. Certainly, we look forward to learning something new and interesting here today. So without further ado, please join me in a warm welcome to the inaugural holder of the Estey Chair in Business Law, Professor Roderick J. Wood.
Thank you. Well, thank you, Clay, for those very kind words. What I would like to do before starting, to say a few words about Justice Estey, as this is his inaugural lecture. Mr. Justice Estey was born and raised in Saskatoon, and he studied at the University of Saskatchewan. He obtained his BA in 1940 and his LLB in 42. He volunteered and served in the Second World War, and when he returned, he went to Harvard, where he got his LLM. He actually taught as at the College of Law for a year, and then moved to Ontario, to Toronto, where he practiced for about 2 decades. He was appointed to the Ontario Court of Appeal in 1973 and to the Supreme Court of Canada in 1977. And I was a law student at the College of Law in the late 70s, and shortly after his appointment to the Supreme Court of Canada, he came to visit the law school and he gave a speech concerning contract law and commercial values. And of course, when a Supreme Court of Canada justice comes to the law school, it's a pretty big event, and so we flocked to see him talk. And as I said, it was here. My classmate and friend Mike Mullany tells me that it was in the moot court room. I actually forgot where it was. I thought it was in the library, but I think his memory is better than mine. So what I thought I would do is that I would like to pursue some of the themes that he talked about when he visited the college more than 35 years ago. Because what he did is that he spoke about some important commercial values and their relevance. Now, what I propose to do is that I will begin by identifying some important commercial values. I will then focus on one particular one, the need for certainty and predictability. I will then look at what three pivotal figures in the development of commercial law have thought about these important values. And I will show how this resulted in a great transformation in the nature of commercial law, a movement away from judge-made law into statute law, this codification of commercial law. I will then talk about a problem with the codification, a problem that comes hand in hand. With codification comes the problem, the corrosive problem of statutory obsolescence. I will finally conclude by some thoughts on, and the theme of my talk, commercial law at the crossroads. I think in Canada, we've reached a point where we have to make a choice as to which direction we're going to proceed along. And I think that choice is an important one, and essentially the future of commercial law in Canada is at stake. Okay, I would like to begin with the identification of some important commercial values. Certainty and predictability. It's necessary to have that certainty so one can plan and build and be confident about what will happen in the future, to make the appropriate risk assessment that is necessary in commercial matters. There's party autonomy, freedom of contract, private ordering, the ability to let people put together their own private structures that best suit them. There are limits, of course, on freedom of contract. There's certain norms, unconscionability, and the like. But subject to that, the framework is one of freedom of contract. There's good faith. And here, Lord Mansfield in Carter and Bohm, almost 250 years ago, advocated a generalized principle of good faith in contract law. That lay dormant for a long period of time until recently. The Supreme Court of Canada in Bazin and Reyneau has rejuvenated this as a more generalized principle. So the value of good faith in bargaining is recognized as an important commercial value. And then finally, the protection of vested rights and the tension between that and the protection of innocent third-party purchasers is another dominant theme and value in commercial law. And those who, in first year, or at least half of you who did the moot on property law, have already encountered this. This is the question of indefeasibility, whether immediate or deferred. Do we protect the owner, or do we protect the innocent purchaser? So these are all important themes. I want to concentrate on the first one, the need for certainty and predictability. And I want to look at how that has been treated by some very important pivotal figures in the development of commercial law. I'd like to begin with Lord Mansfield. He's probably most noted for his decision in Somerset and Stewart in 1772. That's the one in which he found that slavery was inconsistent with the common law. The case marked the end of slavery in England, and in that case you see a very famous statement of his, "Let justice be done, though the heavens may fall." Now, he is equally well known for his work in commercial law, because he's viewed as one of the founders of commercial law. He brought commercial law into our common law system. Now, before that, there was mercantile law, the law merchant, and there were mercantile courts. And they dealt with the practices and customs of merchants. But the common law courts were very jealous of the jurisdiction of other courts, and they essentially squeezed them out. But unfortunately, the common law courts didn't have the concepts or the vocabulary or the inclination to deal responsively with commercial matters. And so we have a problem, and the merchants avoided the Court of King's Bench like the plague, it was said, because the court was simply too slow, too unresponsive, and didn't recognize their customs and practices. And Lord Mansfield set out to change that, because the common law was relatively backward. It didn't have the concepts or the principles that would allow commercial matters to be dealt with properly. He introduced important measures of civil procedure reform that made the courts quicker, more responsive, faster. And then what he did is that he built up a body of commercial law. Now here's what he said about certainty. Here was his thoughts about the need for certainty. He said, in all mercantile transactions, the great object should be certainty, and therefore it is of more consequence that a rule be certain than whether the rule is established one way or the other, because speculators in trade then know what ground to go upon. So, in his view, it was important for the common law to build up a set of commercial law principles so that merchants could be guided and could use those principles to plan, to know that if they did so, that certain kinds of outcomes would be available to them. So he thought uncertainty was an overarching, important commercial value. And so how did he go about this? Well, he did it in a number of ways. He was very, very learned. He was trained in the English common law system, but he was also familiar with Roman law and with the civil law jurisdictions, and particularly the commercial law in those countries, which were much more advanced at the time than in England. Moreover, he set up procedures in which he was able to incorporate the customs and usages of the merchants. And he did that through the commercial juries. Now, it seems strange today because what he would do is that he would dine with the jurors and he would have conversations with them and ask them about their customs and practices. And through that way, he was able to integrate their practices and customs into a common law dealing with these areas of commercial law. So, and he served as Chief Justice of the Court of King's Bench for 32 years. And during that time, the law of negotiable instruments arises, and also marine insurance arises. Now, thereafter, the common law courts are more responsive to commercial needs. And during the 1800s, the law of sale of goods arises. But at this time, it's primarily common law. This is case law, that there is the bills of exchange are dealt with through an enormous body of case law. And sales law is found in an enormous body of sales law. So that takes us to the next pivotal figure in the development of commercial law. And this is Mackenzie Chalmers. He's a civil servant and county court judge, and later takes on the project of codification of English common law on commercial matters. He's responsible for the drafting of the Bills of Exchange Act of 1882 and the Sale of Goods Act of 1893. And in Canada, we have adopted these pieces of legislation. He was a superb legislative drafter, almost unparalleled in his ability to capture complex principles and to state them in rather short sentences. So he's very talented in that regard. And it's quite useful in that we know a lot about him, because after he drafted the Bills of Exchange Act and the Sale of Goods Act, he toured Canada and the United States, and he gave addresses to the Canadian Bar Association and to the American Bar Association and Canadian Bar Associations, and told about this process of codification. Now, by the way, when I'm talking about codification, what I mean is that the common law or the legal principles are drafted into a statute. Now, codification generally is different from just a normal statute in its extent and its ambition. With a codification, particularly a commercial law codification, what you find is an attempt to encapsulate the operative principles of an entire body of law within a single statute. So all of sales law into the Sale of Goods Act, or all of bills of exchange, negotiable instruments law, into one act. So different than the normal statute, which is more limited in its scope. Although different from civil law codes, because with common law codes, codification efforts in the common law system, the common law and equity is always there in the background, ready to fill in gaps if there's some aspect of the statute that doesn't deal with it. It doesn't do away with the common law and equity, but rather it's a comprehensive legislative statement of the relevant commercial law rules. So that's what I mean by codification. Okay, and here's what Sir Mackenzie Chalmers said about the value of certainty. Now, this is a direct quote. He said, "The object of the man of business is not to get a scientific decision on a particular point, but to avoid litigation altogether. On the whole, he would rather have a somewhat inconvenient rule clearly stated than a more convenient rule worked out by a series of protracted and expensive litigations, pending which he does not know how to act." Now, I think you can see the parallel between that and the statement of Lord Mansfield. It is a direct, Chalmers is directly affected by Mansfield thinking about certainty. It's better to know what the law is, even though that may not be the best rule. It's the person in commerce knowing what the law is, then can act and plan accordingly. And that's the greatest value of all, that certainty in knowing what the law is. So he's very much affected by a similar view as Mansfield had as to certainty. But his big move then, that of Chalmers, is that he thinks that an even greater degree of certainty can be achieved through codification, through a transformation of the law from common law to statute law. And moreover, what he does is that he's not a reformist. He's not changing the content of the law. He's not trying to improve the law. He's simply trying to take it from a common law form and put it into a statutory form, thinking that that will make things more predictable and more certain. Now, why is that? Why does a change in the form without changing the content at all? Why would that make things more certain? Now, here's what he says. Again, we're lucky to have quotations from him as to his exact thinking and process in this. Here's how he conceived it. He said that under a common law system, there's actually two processes that are engaged. The first one he called the inductive process. Now, here is where we look through the authorities, we examine all the relevant cases for the purposes of discovering the general principle that the cases affirm. So first we have to find the law, and we find the law by looking through a massive volume of cases to try to determine what the applicable rule might be. And you probably have gone through that process. There's a case, but there's not just one case, there's a whole series of related cases, and you read through a relatively large body of case law trying to determine what the relevant common law rule will be to govern the situation. In fact, one commentator, not Chalmers, somebody else, described it as having to crush several tons of judicial pulp to produce a few ounces of juice. That there's a lot of work that you have to do to figure out what the particular rule or principle might be. And once you do the inductive process, the next is the deductive process, the applicability of the principle to the particular facts. Now, codification doesn't avoid that. You have to determine the facts and then apply the law to the facts. But what he thought is that determining the law becomes simpler and more certain because it's codified. You don't have to read through all the cases. It's there in a fairly simple form in the statute. So that was his innovation. That was where he thought he brought greater certainty to commercial law through this process of codification, this transformation of common law into statute law. Now, Chalmers and the codification of commercial law was not without its critics. And the primary criticism that was leveled against him was that through this process of codification, the law would lose its flexibility, its ability to adjust to new circumstances. Now, he directly addressed this criticism in his writings, and he took the view that this idea that the common law was needed and in order to produce this kind of flexibility, he thought that was overstated. He was unconvinced by that, and he said that the great characteristic of the law of this country is that it is extremely detailed and explicit and leaves hardly any discretion to the judges. So what did he mean by that? Well, Chalmers operated under a particular view of the law in that he thought that, and you can see this expression used throughout his writing, he often talked about it as being scientific in its nature. That the search for the law had a scientific aspect, just like the scientist would observe the natural world and derive the natural laws from these observations. He thought that lawyers would go out and they would examine the cases. And from these cases that you could derive through reasoning and through logic, you could derive the legal rules that would govern new situations. So he thought there was actually not that much discretion. That was simply a process of proper reasoning and logic from the existing case law, and that if you did that, you would be able to answer any new situation that might arise. And by the way, this particular view of the law was very popular and influential. Many of the early law schools in North America was based on that Langdellian model from Langdell at the Harvard Law School. Had this view that you could deduce the principles from proper analysis of the important cases. Now, I would invite you to compare this legal philosophy that expressed by Chalmers with that of Grant Gilmore, who is one of the co-architects of Article 9 of the United States Uniform Commercial Code, the portion that governs secured transactions law. Grant Gilmore was a law professor at Yale Law School, and as I said, he was very influential in the U.S. commercial codification effort, and in particular in respect of secured transactions law. Now, and by the way, he together with Carl Llewellyn, both were associated with the American realist movement, and both of them were heavily involved in the U.S. codification effort, which, by the way, is the most comprehensive and extensive codification of commercial law in the common law world. Now, here's what Grant Gilmore thought about certainty and what he thought about legal change. And he has expressed it rather elegantly in a very short sentence. He says, the only legal certainty is the certainty of legal change. The economy changes. Technology changes. Society changes. And the law adjusts to reflect these changes. Moreover, he thought that these changes were unpredictable. No one had a crystal ball. Nobody could predict the future. And it was folly to try to do so. Here's what he said about codification. He said, we must not delude ourselves as to the benefits which can be derived from a general codification, however admirably executed. Experience with code law has demonstrated that it is impossible accurately to assess or project the effects of contemporary change. Now, you might ask yourself, is there something inconsistent here? I mean, after all, Grant Gilmore was part of one of the biggest commercial codification efforts in the world. And yet he's saying that, well, you can codify, but despite that, you cannot predict what changes the future will hold. So then you might wonder, well, why codify? It's just going to change anyways. What's the point? And I think the point is, if you read through his writing, his view was this, that codifications are useful because they bury the past, that the dead hand control of the past is gone and one can move forward, but that you cannot predict the future, that changes will happen in the future. And so what he was very much, as I said, part of the codification movement, but what he thought was that to be successful, there had to be periodic revision and reform, that you couldn't simply put in a code and think that that was enough, that you would have to revisit it every so often to make sure that it's on track, to keep it up to date, to ensure that new commercial practices that weren't even envisioned are properly reflected. Okay, well, this gives us an opportunity. We have two different views, two radically different views. That of Chalmers, the static view, that the unchanging view, the scientific view, the law is the common law is as capable of generating its answers through logic and reasoning, and that of Grant Gilmore. Let's test it. Let's see how these statutes have held up. And let's see what we think about legal change in light of this experience. I want to look at the two Victorian-era statutes, the Bills of Exchange Act and the Sale of Goods Act. And then I want to look at a more modern statute, the Personal Property Security Act. Okay, well, let's start with the Sale of Goods Act. And if you've taken a course on commercial relations here, you'll have dealt with sales law. I would make the case that it's starting to look pretty threadbare. And after all, I mean, that's not a criticism of it. It was drafted 120 years ago. One would expect that things to have changed since that time. Now, to give you just one example, I could give you many, many more examples, but I'll really restrict it just to one or two. If you look at the Sale of Goods Act, it divides the contractual terms really into two types, conditions and warranties. Warranty, if there's a breach of warranty, it gives you a right to sue for damages. If there's a breach of condition, it gives you as well the right to treat the contract as terminated. It doesn't contemplate anything other than conditions and warranties, and it's drafted that way. You'd think, reading the Act, that it's a division, it's got to be one or the other of those two. Well, what happens then is that, and remember that the Sale of Goods Act codified commercial law as of the late 1800s. What has happened is that contract law has evolved over that time. It's changed from what it was in the late 1800s. So what changes? Well, the celebrated case of the Hong Kong fur, which says, well, no, it's not just condition or warranty. There's another class of term, the intermediate term, in which the remedy you get depends on the seriousness of the breach. Yet if you look at the Sale of Goods Act, it doesn't contemplate that as a possibility. Now, courts nevertheless are able to shoehorn the idea of the intermediate term into the Sale of Goods Act. But what you see is that that's reading the statute alone, you would not have thought that that was a possibility. The Act doesn't really recognize that possibility at all. Moreover, what we see is that in a number of different areas, things have changed. The way that goods are produced and marketed have changed since the late 1800s. In terms of mass production, in terms of transportation networks, in terms of distribution networks. Things have changed, and in many instances, the rules that are set out in the Sale of Goods Act seem less and less appropriate for current circumstances. Okay, now let's take a look at the second Victorian era codification effort, the Bills of Exchange Act. Well, this one really is the poster boy for statutory obsolescence, in that what we find, at the time, negotiability was a highly significant concept, and it was significant because bills of exchange were being used as a kind of substitute for currency. There was a currency shortage, and so bills of exchange and promissory notes and negotiable instruments were being used as a kind of substitute for money. And so people in commerce would be transferring these bills and these notes often so many times, because the way you transfer it is you would endorse the back and you'd transfer the piece of paper to the transferee. This occurred so many times that you ran out of room for signatures on the back of the document, and you had to come up with the allonge, an extra piece of paper that you would attach so you could continue to negotiate the bill of exchange. So negotiability at the time was highly significant and relevant. What we find is that, again, things change. Banks take promissory notes to, in respect of the indebtedness, the loans of their customers, but for the most part, they aren't negotiated. They are negotiable instruments. They have that capability, but in practice, they aren't used that way. And in fact, when they are used that way, we sometimes have problems, and we try to restrict the negotiability through judge-made or statute-made restrictions, because we don't want it to have that property anymore. As well, the bill of exchange was dominant at one time. Now, the most common negotiable instrument we see is the check. Now, if we were to draft a law governing the check today, it would look nothing like the Bills of Exchange Act. Because the Bill of Exchange Act, it takes a kind of negotiability, negotiable instrument, the Bill of Exchange, and then what it does is it uses check as a kind of add-on. It says, okay, all the law governing bills of exchange, that applies, and here's a few extra rules to govern it. So if we were to draft a law governing checks today, what would we do? Well, we would cover things like countermand, stop orders, stop payment orders. We would cover post-dated checks. We'd govern a number of issues that concerning checks. Allocation of forgery losses, we would probably deal with that in detail and in a significant way. Properly allocating the risk of loss. We deal with the bank-customer relationship. We deal with the bank-bank relationship. We do things entirely differently than how it is presented in the Bill of Exchange Act. And then to rub salt into the wound, the check is losing its market share. It's vanishing. And now, it's not going to be immediate, but over time, what we find every year, and still billions and billions of dollars are used, payments are made through check, but that percentage diminishes every year. The electronic systems, the digital system, the debit cards, the credit cards, the store cards, the electronic cash, the PayPals, the mobile banking. There's a digital revolution, and the paper is disappearing. So when you look at this, I think you conclude, yes, there are changes, there are unforeseen changes that one can't predict, and so that codification, I think, does entail that process of revision to cover these technological and other changes. Okay, when I show you the next slide, I think that many in the room, one in particular, will probably understand the area of law I'm next going to talk about. Am I right? Now, what area is that? PPSA, Personal Property Security Law. I think that it's fair to say that Professor Ronald Cumming is the individual most associated with the development of Canadian personal property security law and its transmission to amongst the common law provinces and territories, and then internationally in its influence on the development of secure transaction law in other countries. And I must say I'm very grateful to have been able to collaborate and work with him over the years on many projects dealing with personal property security law. Now, PPSA, the Personal Property Security Act, it addresses matters of certainty through a number of means, but I'll mention two. It makes two really important moves towards certainty. First, and it's really different from the Victorian-era codifications. These simply attempted to take common law and put it into statutory form. The ambition of the Personal Property Security Act is much different. It is designed to change the law and to change it in many radical ways. And it makes two really, really important moves. The first is that the move for simplification. The old common law, it had a multitude of different security devices, each governed by their own rules. And what the PPSA does is adopts a single concept, a unitary concept of a security interest, and applies the same body of law to that. A great simplification and greater certainty by that move. Then secondly, what it does in terms of priorities is that it simplifies the resolution of priorities and makes it more predictable. And it does so by a computerized registry system and the linking of priorities to time of registration. So it does more than that, but that gives you an idea of its agenda in creating certainty through legislative reform. Moreover, what we see is, again, I think it's fair to say that the PPSA is probably Canada's most popular legal export, in that other countries are using the Canadian model in the reform of their secure transactions law. New Zealand in 1999, in fact, it used the Saskatchewan Act as its inspiration. And you can see that it's even got links in the New Zealand statute to the references to the Saskatchewan law. Australia in 2009 enacted a PPSA. It's a little more distant from the Canadian model. They did some of their own innovations, but very clearly influenced by Canadian developments. Now, recently I found that a number of other countries, Micronesia and Polynesia, have gotten into the game. I was looking at the Palau Secure Transactions Act, and it's virtually a carbon copy of the Saskatchewan PPSA. Moreover, it was backed by the Asian Development Bank and the government of Australia. So I would have thought that they would have used the Australian model. But no, they're using the Saskatchewan model, and I think that tells you something about the view as to the benefits of that particular statute in terms of the clarity and its influence. Okay, so here we have the PPSA, the sort of like the crown jewel in Canadian commercial law that is being used in other countries. But even here, with our best legal export, they're still here with our newest act, which seems to be periodically revised. The Saskatchewan, this is the second generation of PPSA, and the provinces that originally enacted the PPSA, Saskatchewan, Manitoba, Ontario, all have subsequently revised their legislation. So it looks like we have new legislation, periodic reform, measures to improve certainty and predictability. It seems like we've got a lot of good things happening. Even here, I think we can detect some troubling signs of inertia. And I would refer to this. The problem, I think, in pursuing this agenda of periodic revision and reform of our commercial codifications is that we have a problem, particularly in Canada, with uniformity and the value of uniformity and strength of our uniform uniformity of law bodies. And the reason it's a problem is this, because on one hand, we want our commercial laws to be revised, but on the other hand, we want uniform laws across Canada. So if Saskatchewan revises its PPSA to cover new situations, the worry is that if it does so alone, then it becomes out of step with all the other provinces who haven't revised. And so then it undermines the important value of uniformity. So you have this sort of pull between wanting to reform but also wanting to do so in a uniform way. So what one would really want to and need to strengthen is the idea of uniformity. The United States has been able to do a much better job with its secure transactions law in ensuring that all the states, when it comes to revision, they act at the same time and in lockstep. And so they all put in their revisions and changes at the same time. And unfortunately in Canada, we lack, I think, that capacity to ensure that when changes are made, they're made across Canada in a uniform way. We also have problems with outdated federal provisions. It's been a number of years. Excuse me. It's been a number of years, many decades, since Canada, the Canadian provinces and territories have adopted PPSA law. The federal provisions still use old terminology. They still talk about chattel mortgages and liens and charges. They haven't figured out yet that there's a new personal property security regime that has swept the other provinces. So we have antiquated federal laws that don't interact properly with the provincial laws. So even with the most modern and most up-to-date area of law, even here, we have some signs of inertia. Okay, well, what are the responses to this problem of statutory obsolescence? And the problem of statutory obsolescence really is related to our important idea of legislative supremacy. When we codify, when we put commercial law into statutory form, what we do is that we, applying the concept of legislative supremacy, we say that, well, only the legislature can change what has been enacted. Okay, so in order to have a properly functioning, codified commercial law, we do have to have periodic revision by the legislatures. We have to have reform and review and on a periodic basis to ensure that it's kept up to date. And the problem is that this is difficult to achieve. And you might say, well, Parliament, the legislatures, they should simply review it and keep it up to date. Well, why can't they do that? Well, it's a complex problem, and there's many reasons for it, and I could probably give a whole lecture just on that topic alone. I'll give you, mention a couple of points. First of all, in terms of political payoff, law reform, particularly technical law reform, is given a very low priority. It has, the politicians typically don't understand it very well. It has risks to them, but few rewards. And so it's not very popular. It's hard to find a champion who will back the cause and to get the bill through. Moreover, what we find is increasingly there is a competition for legislative time. Different government departments have their own legislative agenda, statutes that they want enacted, and you're competing with them. And it's difficult to get these other matters of technical law reform in. I was talking to a legislative council in Alberta, and I was surprised they're talking about not just 1 or 2 years, sometimes 3 years in advance as to when they would think there'd be a window for some legislative change. Okay, so what can we do about this? Well, there's a few things that we can do, things to slow the aging process, to try to extend the shelf life of these statutes. One of them, the use of regulatory power. You can use regulation-making power so you can change monetary limits. You can, for instance, in the PPSA, very vital that you use a regulation-making power in order to ensure that the computerized registry system can be properly adjusted without having to go and seek a change in legislation. So having that flexibility so that you could alter and change and take advantage of new technologies, you can do that through certain regulation-making powers. And as I said, in some commercial statutes, that's quite a vital aspect. You can try mandatory statutory review. Now that's done in the Bankruptcy and Insolvency Act, where the statute, when it's enacted, provides a review period. It requires the government within a certain period of time, such as 5 years, to review the body of law with a view to proposing some further revisions. So that has been used since the starting with 92 in the Bankruptcy Insolvency Act. It was used in Australia with their PPSA. After enacting, they put in a 3-year review period where a review was required to, a mandatory review was required to see if all things were working properly and in order. Another thing that you might do is open textured drafting to try to keep, the idea here is that the more precise you are, the faster your statute will become obsolete. So in some cases, through more generalized drafting, you can try to build in that flexibility into the statute. Probably the best example of this is the Companies Creditors Arrangement Act, our restructuring law, where it creates a fairly loose skeletal statutory regime and gives discretion to the judges and allows, therefore, a great deal of flexibility in terms and adaptability of the statutory regime to cover new situations. Now, there's also, these are the legislative responses. There's also responses of judges. Now, Grant Gilmore, I think commercial lawyers have always recognized that this happens, that even though that there is a codification, that the judges have the power of interpretation, and they can change the law effectively through interpretation. Now, the problem with this, and what Grant Gilmore says, is that the judges have, of course, always had and have exercised the power to achieve necessary reforms by the process of disingenuous, even deliberate misconstruction of statutory texts. That is a bad way of dealing with the problem. It leads to a state of law that is fragmented, obscure, inconsistent, incomprehensible. And you can see why that is. Because, yes, the interpretation allows that flexibility to change, but what happens is that there's an ever-widening divide between what the statute appears to say and what it's interpreted to actually mean. Now, Grant Gilmore goes on, says a major problem of law reform over the next half-century will be the reformulation of our theories about the allocation of power between court and legislature. And there are some commentators who actually have advocated an even more radical response to this, to the problem of statutory codification and statutory obsolescence. And in particular, Guido Calabresi, he was a law professor at Yale at the time, but now the judge of the United States Court of Appeal. He wrote a book, A Common Law for the Age of Statutes, and he argues that the courts should have the authority to modify statutory rules in the same way that they can modify a common law rule if the statute has become obsolete. Now, that may seem a highly radical or even a subversive idea. After all, what are you doing? I mean, isn't this against our concept of legislative supremacy? Is this not a kind of judicial activism in private law that is being proposed? Now, Calabrese would argue that, in fact, courts are already doing it. They're just not admitting it. That they're doing it through interpretation. They're doing it under the guise of interpretation. And he argues that it's better to have candor and honesty about this rather than what he calls trickery and subterfuge. Now, if you think this is outlandish, if you think this is far-fetched and that this is pie in the sky and that it's unlikely to happen in Canada, I would invite you to consider the case of the Lac-Mégantic trail derailment. The tragedy, we have this trail derailment. It causes a huge explosion, flattens a good portion of the town. It kills 47 people, injures many more, and causes a great deal of pollution to the town site. The Montreal, Maine, and Atlantic Railway Company is hopelessly insolvent. It does not have either the assets or the insurance coverage to cover all the claims. The remediation costs more than exceed the insurance coverage and all the assets, not to mention the personal injury claims. Okay, so the judge, Justice Castonguay, deals with this matter. There's an application under the Companies Creditors Arrangement Act because that would provide a mechanism to deal with the settlements and to deal with the claims of this insolvent company. But there's a problem. The problem is that the Companies Creditors Arrangement Act and the Bankruptcy and Insolvency Act provide that railway companies cannot proceed under the, either the Companies Creditors Arrangement Act or in bankruptcy. There's a legislative restriction that prevents railway companies from commencing. Now, why is that? Well, Justice Castonguay looks and he says, well, it's a legal anachronism. Because at one time, we have these ancient and obsolete provisions dealing with insolvency of railway companies, but they are totally unsuited to current needs. They really deal with disputes between bondholders and the company, and there's a number of mechanisms that render them totally unsuitable for the purpose. So what does he do? Well, he says, well, there's a legal vacuum. The regime that is available is anachronistic. I'm not going to apply it. He allows the CCAA proceedings to go forward despite the legislative restriction. So it seemed to me that that would be a very good example. Now he said, I have the inherent jurisdiction, I'm filling a gap, but the reality is that he did not, he refused to apply the statutory restriction that would otherwise prevent railway companies from proceeding. So if you think it's far-fetched, I think the answer is, well, it is happening. Okay, well, to conclude then, we've seen that there are some measures that we can take to deal with statutory obsolescence. There are certain techniques to slow the aging process. There are certain judicial activities, sometimes problematic, but they're available. But I think that Grant Gilmore is correct that once we've set off on a project of codification, there's no turning back. We have committed ourselves to a series of periodic reform. And so in order for this to work, we have to ensure that that reform process continues, that our laws don't become irrelevant, that they are updated, and that law reform measures and uniformity measures are healthy and strong. So I think, although it's difficult and time-consuming, in Canada, the agenda forward is to try to promote measures of law reform, of uniformity, whenever we can. And for those aspiring lawyers in the future, when you have an opportunity, whether you're acting in government or as a politician or as a member of a professional organization like the Canadian Bar Association, try to remember that this renewal of the law is important. Now, what happens if that doesn't occur? Now, we're at a crossroads. We have to make a choice. We can either continue to update and reform our laws, or we could just leave them and let them become obsolete. If we do that, what will happen? Will commerce grind to a halt? No, it won't. It won't. It never has. I mean, what will happen is that we'll turn a full circle, and we'll go back to what it was like before the time of Mansfield. Commercial law will have lost its function, its facilitative function, and it will simply be a hurdle that commerce will have to get over, which they will do through arbitration or drafting around the problem to work around. But commercial law will have lost its purpose, and I think that would be a very unfortunate thing to happen. So there you have it. There's history of commercial law in 250 years compressed into 50 minutes. So I'd like to thank you for attending and for your attention, and I'd be happy to address any questions you might have. Mm-hmm. Well, yeah, Carter and Bohm, now it's an insurance case, and Lord Mansfield, now the thing about Lord Mansfield is that he was very interested, he was trained as, he's Scottish, but he was actually trained in the English common law. I think at the age of 14 he traveled like 400 miles on his own, and it took 8 weeks or something like that. But he traveled, and he was trained as a common law lawyer. But what really is remarkable about him is that he has mastered that approach, but he also looks for principle, the principled analysis. And that's why you read his judgments, and so often they even after 250 years, they speak today. They resonate. And so in that case, he is arguing for a more generalized concept of good faith in contract law. Now, what happens is that subsequently the other judges don't buy into that, and it's marginalized. It's limited to the context of the insurance contract, where disclosure, everything. So it's not treated as a doctrine of general application, but it's restricted. But then what we find is that although we don't recognize it, it's weaved through the whole fabric of the law. We find good faith in various places, but it's rather chaotic in the way it's deployed. And then what we have then at last is a recognition that this idea of good faith is an organizing principle in contract law, but it's also recognized as a standalone generalized concept, at least in terms of honesty, in terms of the bargaining process. So, and in that case, the Supreme Court of Canada makes reference to Carter and Bohm. So you have that 250 years of sort of, maybe not dormant, but it was marginalized, and finally it emerges as a standalone concept, which just shows you the power of Mansfield's thinking. Oh, and by the way, it's also used, the PPSA recognizes good faith. So in other contexts, like in statutory context, this idea of good faith is present.
I've heard people comment that the common law is not developing as it should, for two primary reasons. One is the use of private arbitrations, and the second is pre-trial settlement conferences, which have a success rate of below 80% in Saskatchewan. And the theory is that the law cannot keep up with what is actually occurring in real life because the law doesn't know what's occurring.
Yes, that's an excellent point. It becomes like a black hole. It drops out. It becomes invisible. And the more successful the arbitration becomes, it gives you an answer. It gives you an outcome, but it doesn't give you that guidance as to the future. And that's what Lord Mansfield was so interested in producing, because it is the same kind of problem, is that they had arbitrations back then primarily to avoid the common law courts. And what he said is, yes, you get an outcome, but things like negotiable instruments and the like shouldn't just depend on individualized decision-making with no principle. So you lose the idea of a principle as a source that can guide you into the future. So that that is a danger. I don't know what the solution to that is. And also the rate of change. I think that's something, you might think that today things are changing fast. There have been times in the past where things have also changed very quickly in terms of technology and the like. And yes, it's true that it's difficult in those times for the law to keep up. But I think that the idea of that change is inevitable, and that these are problems that we do have to be sensitive to and that we have to work towards. So I think we do have to maybe think of some substitutes to, if that's happening, to provide other mechanisms to provide the necessary guidance and certainty.